Alex here with part 11 of the My Docket series on child custody and visitation. We left off in part 10 with me having gone over the orders entered by the district judge, not the domestic master, the district judge in the child custody action that I had instituted. And now we are jumping back to the protective order action that my ex had instituted. This is going to be kind of a curious video. First off, I almost skipped over my disclaimers, so let's go into that first. Number one, my ex's parental rights have been terminated. This case is completely and totally closed. I'm actually not in the middle of this right now, and the purpose of this series is to provide the viewers with one big gigantic example of my 8-year-long high conflict child custody dispute in chronological order from beginning to end. And you can actually check out the details as to the entire disclaimer and the entire purpose of the series in the video part 0 of the My Docket series. But what I was trying to say is that it's going to be a little bit of an odd video because what my ex's attorney did in this case is really weird. So apparently my ex wanted some kind of holiday visitation set forth, and her attorney was supposed to request that at the previous hearing. And when I mention a previous hearing, I'm talking about the hearing video in part 8 of the My Docket series. That is the extended protection order hearing. Apparently her attorney was supposed to request some holiday visitation and she forgot. And I remember vividly my ex being really distraught about it. She sent me some text messages, maybe an email. She might have even called me, putting on the waterworks about how she was supposed to take him on a vacation and now she couldn't because I had visitation during that time and it was going to get in the way of it. And I thought it was kind of odd of her to go through all of those theatrics because my ex's attorney had filed a motion in the protective order action asking the judge to enter an order allowing her to exercise that vacation. And she also did it with an ex parte motion for order shortening time. I could spend probably 30 minutes just talking about those motions alone, and I'm not going to do that because I have a separate video on that topic. And the video is titled, I think it's titled Continuances, Shortening Time, and Enlarging Time. It's something like that. You'll probably see a card pop up in the top right hand corner of the video pointing you out the location of that video. But anyway, I thought it was odd because I was thinking to myself, you know, I just got these motions and I never intended to fight them. They were okay. I have to be honest. I mean, when you initially get something like that and you're just, you know, you're a human being, your first instinct is emotion, and it's going to be, no, I'm not letting you do anything, not after you lied about me, you know, at this order of protection hearing and got a restraining order, an order of protection for 3 months. You know, it's easy to, you know, feel that because it's like you want revenge, they just lied about you and the judge bought it hook, line, and sinker, and now it's like, fine, my revenge against you is going to be that you can't go on your vacation. But very quickly, the brain takes over, and my brain was like, you know what? I don't need those days. What am I gonna, you know, I could just take different days. I don't need to specifically have those days. I didn't have any plans. And I guess that's what distinguishes the ordinary parent who is frustrated and suffering in the process, the litigation process, from the high conflict, potentially personality disordered, potentially emotionally immature parent. And when I got those calls and messages, I imagined that she was panicked, and I imagined she thought that she had to somehow convince me. And typically her method of control was emotional blackmail, basically just cry. She had the other methods, but those that have to do with threats and stuff like that, those tend to work better when you're actually in a relationship, not when you're already litigating. Something like that would have just probably made me say, well, fine, let's fight it out. But when I agreed, I had already had it in my mind to agree. I had already planned out on telling the court, hey, if she wants this vacation day, it's fine with me. So this was a very strange experience because I didn't think that attorneys did that. I thought that attorneys were asked to do things and then they'd go do them. I thought that's why they were paid so much money. So when I found out, that her attorney forgot to make that kind of request, it kind of made me feel like, well, I'm glad I didn't hire one. It's not like it was a choice. I didn't have the money to hire one anyway. But I can't imagine what it feels like to fork over thousands of dollars for an attorney, for them to just forget to ask for something that's so important to you. And it could have really turned into a crazy situation. If I was a high conflict person, I probably wouldn't have said, no, I'm going to screw you over. I probably would have said something like, oh, I'm taking a trip on that day. That's typically what the high conflict people do too. I talk about that in the live stream on narcissistic pretexting. But anyway, that kind of covers the emotional weirdness behind it all. But I do want to talk a little bit about the procedural weirdness too, because my ex's attorney didn't just ask for that vacation time. She also asked for a few other things above and beyond in that motion. And it was also procedurally awkward because that domestic master isn't supposed to be dealing with those types of issues, custody and visitation. They're just supposed to be dealing with whether or not an order of protection should be issued and extended. So for the lawyer that she paid all that money to, that went to law school, for her to go and file a motion trying to put more custody issues before that domestic master, it shows either incompetence or maybe desperation. It could have been desperation. She might have thought that the district judge would have denied her motion. She might have thought that the district judge would have taken too long to rule on it. She did mention in part 8 of the My Docket series in the video, the domestic master did mention personally having a relationship with Kathrine Berning. In fact, it was substantial enough for her to place that on the record and warn me about it. So she might have thought that she needed her friend to make a ruling on this because she messed up. She needed to fix it really quickly. And these are all possibilities, and really I want to lead a little bit more into what it was that my ex's attorney asked for when we actually go. And that being said, let's take a look at what my ex's attorney has filed. Here we have my ex's motion to set holiday visitation. This is another custom paper that is being filed by my ex's attorney. Pretty soon I'm going to figure out as a self-represented party that I can do this too, and I'm going to stop using those self-help forms. But I did want to just point that out because as I do start to learn how to create my own custom forms, I am going to very much emulate and assimilate the techniques used by my ex's attorney. So scrolling down, and as with all of my videos, you will be able to download these if you look down in the description below and click on the links. And I'm only going to go over the areas that I want to highlight for my viewers. Any other areas I'm going to glaze over depending on how important they are to point out, and of course their relevance to this specific video in question. The initial area, the initial section, paragraph 1, just goes over some what I call boilerplate language. Typically tells the court who is coming before it to request in writing a certain thing, and in this case that thing is holiday visitation. This last sentence right here, that the motion is based on the following points and authorities and all pleadings on file herein, that's just a quick way to, number 1, reference all existing pleadings, and number 2, let the court know that this particular document consists of points and authorities. It's not just plain language, it's not just plain English asking the court, please kindly let me have what I want. It's going to contain citations both to fact and to law, the court rules, stuff like that. And this is something that I talk about in detail in my video motions, so definitely watch that video if you want to learn more. Here we have points and authorities. The points and authorities consist of the factual background and the legal analysis. Starting off with the factual background. Again, I'm just going to point out things that really jump out at me that I think it's important for the viewers to know. Most of this factual background recaps what I've already covered in parts 8 and 9 of the My Docket series. So I'm going to be scrolling past these. The attorney is just... So with the first paragraph, the attorney highlights what the court has already decided in parts 8 and part 9 of the My Docket series. The second paragraph is a request. She apparently planned a trip to San Francisco. She'd like to take our son with her. She attached an affidavit. I've mentioned this in the video motions. The affidavit is mandatory. It is required under the court rules. I'm not going to go into why because I talk about that already in the video motions. It's definitely a must watch. So the affidavit, by the way, it's just a list of statements, allegations, or facts under oath, and that's key. The statements are sworn under penalty of perjury. We'll take a look at that when we get to it. So these are the dates that she planned the vacation. She's mentioning how 2 of those days fall on my time. I need to stop, by the way. I hate to say this, but a lot of times in these situations, somebody will just violate the court order. They'll just take the kid and violate the order. And then when you try to enforce it, it ends up in front of the court on a contempt of court. And so many judges will just say, oh, well, you shouldn't have done that. Shame on you. And then they won't hold them in contempt of court. They'll typically give the other party who lost some of their time, they'll give them a little bit of makeup time. The good judges will give them like double the time to, you know, make sure that the other parent understands that they're not supposed to do that. But I just wanted to let people know that in a really dysfunctional way, it's almost like this motion didn't even matter, because if my ex had violated the court order, which she does do on many occasions throughout the case, ultimately nothing happens to them. They don't really suffer any consequences. Not until they do it like a bunch of times. So she's going to provide me the contact information. It says, put in leave for her job, to visit the grandparents. All of these promises to give me the contact information, grandparents' address, and stuff like that, it makes me wonder if she actually did that. I highly doubt it, since this was a problem throughout the entire child custody case. Oh, look, she's offering that I take Thanksgiving instead. So that's good. That's probably why I just was like, okay, that sounds fine. So argument is the second of the 2 sections in that are the points and authorities. The argument I also call a legal analysis. This is where the attorney, or anyone really who's filing a paper, this is where they cite the rules that give the authority and compel the court, if it, you know, if applicable, to do what it is that is being requested. So right here, the attorney is citing court rules that mandate that the court make a decision on motions put before it. So the attorney is telling this domestic master, you must render a decision. She's not saying that you must render it in my favor, at least not with this first sentence, but she's saying that pursuant to these rules, you cannot just ignore this. Now she's citing case law, which is a first case on best interest. There's a lot more to Ellis v. Carucci than just that, but we're not going to go into that in this video. Some stuff on relocation. Oh, well, Potter v. Potter is relocation, but it also discusses best interest. I'm imagining that's what she cited it anyway. Continuing to scroll down. You know, you could argue this both ways, really, because if the other parent had some kind of holiday travel set too, what's the court to do? In this case, I don't have anything really to do on that day, so. Some generic language here. You mean throwing the phrase around best interest like this is pretty common with these attorneys. They'll say, And whatever it is that they're requesting is supported by the best interests. Doesn't matter if there's other alternatives that are better for the child or not. And she's just doing her job as an attorney. Any other attorney would do the same thing, trying to fix their mistake. This is the certificate of service, just letting the court know that I was served. Oh, personally served again. This was probably because it was an emergency on the, well, this is because she asked for shortening time. I'm imagining that's why she wanted to serve me personally. So, I think I've talked about this before, but there are two types of ex parte motions even. One of them is a type that you need a really quick decision, and with that type, you still do notify the other party. Usually there's like a rule even that requires something more substantial than just sending them the document through the mail. I guess in this case it kind of is obviated because it's personally served, but I've seen rules that require like a phone call or a fax, or I don't think an email, but I'm sure some of the rules in some courts have modernized to the point of requiring that you send an email. The other type is the secret type, that you do not show your opponent, because if you showed them, that would frustrate the entire purpose of the motion. And this is not the secret type. She just needs a quick decision. And if you want to learn a little bit more about ex parte motions, definitely watch the video Ex parte Perils. Another of these affirmations. I've talked about these so many times that I'm not going to do it anymore. My early videos 1 through 10 go over the affirmation repeatedly. And this is the motion opposition notice. I've talked about this before, but I will glaze over it again today. This is just a document that's required specifically by the 2nd Judicial District Court, which means not even all of Nevada requires it. Just one district in Nevada requires this. Other districts may have a different form, like Clark County. They have a similar form. It looks different. Different boxes are checked. Different information is on it, and there's a different fee. This is a form that you fill out the check boxes following, in order from top to bottom, and these will tell you whether or not you have to pay a filing fee of $25. In this particular case, my ex's attorney has filled out the no box under number 1, which immediately says she does not need to answer any other questions and she does not need to pay a filing fee of $25. So let's move on to the next document. Oh wait, first off, I need to check and see if this is it. One more. Oh, we have an index of exhibits. Here we have Exhibit 1, which is my ex's affidavit. And this is what you need to support a motion. At least in pretty much all of Nevada, this is a requirement. I'm sure other states that are similar to Nevada have the same requirement, that motions require an affidavit. I know that Nevada's a notice pleading jurisdiction. I don't fully know what that means. Maybe someday I'll ask an attorney about it. But I've heard that there are other states out there that are not notice pleading jurisdictions, and the way that they handle filings of motions and what is required to support them is very different. So I can't say that this is what's required in every single state. But not specifically the language in this affidavit, but an affidavit of some sort or multiple affidavits are required to support motions. And there may be exceptions to that. Like, for example, maybe if an attorney needs to file a motion that involves pure questions of law that alleges no facts of any sort, that might be a situation where no affidavit's required, because nothing needs to be sworn to under oath. If it's just legal questions and legal questions alone, the court can make a ruling on that without making any findings or even holding a hearing. The court can just make a summary decision. Getting a little bit onto a sidetrack, but taking a look at this affidavit, it's nothing that jumps out at me as important. It pretty much is everything that the attorney already stated in the motion, and it's just supporting the attorney's argument with allegations from the actual party. And here she's even swearing under oath what it is she's going to provide to me. Let's move on to the next document. This is the ex parte motion for order shortening time. In some cases, you see these all the time, especially in Clark County. These get filed all the time. In Washoe County, 2nd Judicial District Court, these don't get filed very often. At least in my entire 8-year-long high conflict child custody dispute, I didn't see them very much. Maybe there might be one other time, maybe 2 at most, where one of these gets filed. It's a very simplistic motion. It's just asking the court to shorten the time limit for me to respond. A little bit ironic here because my track record at this point is responding to my ex's filings within like a day. So it's a little, like it's not really necessary. I'm sure that I responded to this within a day or maybe even the day of. But yeah, you don't really need to shorten time with a father who's representing himself and is totally panic-stricken at being put through the court system. That father will file stuff really quickly. And that's what I was doing at the time. I was filing stuff so fast. So I don't know. I haven't looked into the next filing, but I imagine that I responded to that motion within a day or two. And so the ex parte motion for order shortening time probably didn't even really matter. And it's just, here it is citing the rule that allows the court to shorten time. So the attorney is letting the court know that she has the authority to do this, to shorten the time that I have to respond. And it's also clarifying that if the court does not shorten time, then there won't be enough time for the court to be fully briefed, and by the time the court is able to even make a decision, it'll be too late. It'll frustrate the entire purpose of my ex's motion. We have another affirmation. I'll skip right over that. Skipping. Oh, wait a minute. Oops. The attorney messed up. That's not supposed to be in page 2. That's supposed to be at the back. So this page here, which is page 3, is supposed to be page 2. And the affirmation that you just saw is supposed to be page 3. No big deal. I'm sure the domestic master was able to read it just fine. And another certificate of service and personally delivered. I don't see anything mentioning it was emailed to me or that I got a phone call. But suppose it wasn't required. I'm not going to double check the rules right now, but I have seen that is something that is required for like ex parte temporary restraining orders. Just maybe not for ex parte motions, for shortening time. Let's check the next. Oh, wait, I think there's one more thing. One of these again. Family court motion opposition notice. My ex's attorney fills it out, indicating that she does not need to pay a filing fee. Okay, this exhibit I'm going to skip, and that is because this is a clone of the motion that we just went over. So she basically took the motion that she filed separately and attached it to the back of this ex parte motion for order shortening time as an exhibit. It is an identical clone, and there's just no reason to go over that. Moving on. Request for submission. I have talked about these in a video that is crucial for people that use these. A lot of courts don't even bother with these. In Nevada, the 2nd Judicial and 4th Judicial District Courts use the request for submission. And if you do not file this, the judge will not even know that they need to make a decision on that case, and your matter will just be sitting there pending forever and ever and ever. And you'll probably think that the judge just ignored you and didn't care about your case, when in reality they had no idea that something was even ready to have a decision on it. So my ex's attorney is filing this document to let the court know that a decision needs to be made on the ex parte motion for order shortening time now. Want to point out to my viewers that take notice here that this request for submission does not submit the motion. It only submits the ex parte motion for order shortening time. So she's only submitting to the court the issue as to whether or not the time limit needs to be reduced for me to respond. So definitely something to take note of. It's easy as a self-represented person to just be like, well, can't you just make a decision on everything? It's all there. Well, that's not how it works. I still have my due process rights. I have a right to respond to that motion if I want to. And the only thing that I don't have a right to respond to is my ex's request to shorten my time limit. And that's the only thing that this attorney is submitting to the court right now at this point. Please watch my video, Request for Submissions, if you haven't seen it yet. I talk a whole lot about these. In that video, I go into much more detail. Scrolling down, we got the certificate of mailing. This one was mailed to me. The request for submission was mailed to me. I'm not sure why. They may as well have just given it to me at the same time as the ex parte motion for order shortening time, but for some reason they mailed this document to me. Another affirmation, which I will skip over. Going into the aftermath here, I imagine that my ex probably did have to pay for her attorney to file these documents. On the one hand, some attorneys might say, since I messed up, I'll do it for free, but there's no way to really know under the circumstances, and because I am erring on the side of caution, and throughout the entire series I've been kind of sticking with the low bound on what my ex's attorney is charging her, it probably wouldn't be too inconsistent with reality if I continued that in this video here. And as I mentioned earlier, for all I know, she's been charging her a whole lot more than I'm quoting. And if that's the case, then issues like this, where there are mistakes, where her attorney possibly did things for free, will kind of wash out. But let's take a look at the costs for both sides. It's going to be $0.00. I didn't file anything. My ex filed 2 documents, or her attorney did, and both of those documents did not require a filing fee, so $0 in costs right there. When it comes to attorney fees, I didn't use an attorney to file or review any of these documents, so that's $0 in attorney fees for me. For the motion to set holiday visitation, I'm going to guess, and I'm kind of being nice here because I'm imagining that her attorney kind of took a little bit of ownership of this. I'm going to guess that she charged a half hour on that motion to set holiday visitation. And for the shortening time, I'm going to guess 15 minutes. And for the request for submission, I'm going to guess another 15 minutes, which comes to a total of 1 hour, which comes to, if we go with the $250 an hour rate that we've been sticking with throughout the series, a total of $250 in attorney fees. If anyone has any questions, as with all my other videos, feel free to post something down in the comments below, and I will see you guys next time.